This bill helps get that balance right. I commend the bill to the House.
The question is that the motion be agreed to.
Mr. Speaker.
I call the Honourable Phil Goff.
Mr. Speaker, the Labor Party will be supporting this bill to select committee, and it will be doing so because we need to look very closely at whether this bill is real and necessary in what it sets out to do and will actually achieve that, or whether this is simply political spin. There is no doubt that the aims of the bill that are improving public safety and ensuring the integrity of the bail and justice system are proper aims. The question that we have is whether this bill will actually deliver on those aims. I noticed the Attorney-General, when he was introducing the bill, said that they have already passed a bail bill. In fact, they introduced it in December 2008 to reverse the Labor policy of softening up conditions for bail. I remember that debate, Mr. Speaker. I remember going to look at the factual basis for the legislation, which was actually just an election slogan. And what did we find? That the net impact of that bail law passed by Simon Power, introduced in December 1999, would affect 10 people a year. 10 people a year. Mr. Speaker, there are 15,000 people remanded on bail every year, and what we had was a bill that predicted maybe 10 people would be affected by being put into jail. Now, I have no problem, sir, with tough bail laws. We start from the position that a person is innocent until proven guilty. That is a fundamental precept of our English system of justice in this country. And I don't think even the Attorney-General or the Minister of Justice would disagree with that comment. That is the principle that the judge begins with. And then that principle can be overturned if there is a justifiable reason. And the justifiable reasons are, one, that there might be a danger that the offender, or the alleged offender, the defendant, would abscond. And if there is a real and provable danger, then that is a good reason for denying bail and remanding the person into custody. The second and justifiable reason is that the person who is the alleged offender is at real risk of committing further and serious offending in the community. And where that is demonstrated, sir, I have absolutely no problem with that person being remanded in custody. And in fact, about 20% of all people charged with offences are remanded in custody. So the judges are using the discretion that they have to make that judgment and to remand in custody. Nor do I have a problem, Mr. Speaker, with the principle that there should be a reversed onus of proof in particular cases where it's up to the defendant to prove that he or she should be given bail rather than the prosecution to prove that they should not. In fact, Mr. Speaker, the substantive act, the Bail Act of 2000, was an act that I passed. And I took a National Party bill and I moved an SOP on becoming Minister of Justice precisely to reverse the onus of proof for categories of people who are offending at very high levels on bail. I took career burglars, and you only get 1 in 10 burglars actually convicted, but of those that were charged, 26% of them were offending on bail. They'd be given bail in court, and on the way home for tea, they'd commit another couple of burgs. Now, that wasn't good enough as far as I'm concerned, and we took an action and said, reverse onus of proof, those people have got to prove that they're safe to have in the community. And I also took another hardcore group of people. These were people that already had substantial convictions. And I estimated, using the information provided to me by the Ministry of Justice, that the rate of offending in this hardcore group was about 90%. 90% of them, while on bail, would re-offend. And we changed the law. We took the weak law that the national government had proposed in 1999, we changed the law, we toughened it up, And did it have an impact? By God, of course it had an impact. 2,000 people a year were remanded in custody that would otherwise have been given bail. And that's about 269 at any time. And that did have an impact, sir, on the level of offending while on bail. And what we were able to do that and stay within the Bill of Rights. We made sure that the legislation was within the Bill of Rights so that before people were presumed innocent and therefore the prosecution had to demonstrate why they should not get bail, we had good grounds for doing that. And the Crown Law Office upheld that was within the Bill of Rights. So we passed legislation. It was expensive legislation. It cost $30 million in extra prison space to lock more people up on remand. So I don't want to hear the Attorney-General or anybody else saying that a Labor government hasn't been prepared to take tough decisions on bail, but where that was justified. If you can justify it, and if it's about safety of the public, and you can prove that you can make people safe, then we'll support it. But if it's just a bit of political spin, something that was invented for an election campaign, and they know that it's not going to make a difference, then I'll oppose it when I've seen the evidence. If that's what the evidence shows. And actually I'd expect the Select Committee to do it, because that's the job of the Select Committee. Take away the political flim-flam, find out whether what is being proposed is justified on the facts, on the evidence, on analysis, on cross-examination of the ministry officials to show that that's going to make a difference. Because I'm not interested in doing what National and Simon Power did in 2008, which was to pass legislation where the publicity vastly exceeded the actual impact. 10 people a year when we were talking about 15,000 people a year getting bail, Mr. Speaker. So I want to know, the critical thing I want to know at the Select Committee is what is being proposed here justified in terms of the impact that it will have genuinely in improving public safety? Because there are people that are arrested for offending that shouldn't be let out on bail. And there are people at the moment who are let out on bail and who keep offending. So I will look at this, as will my colleagues on the opposition side of the Select Committee, to find out whether this is real, whether it will actually have an impact that increases public safety rather than being something done, as it was last time by the National Government, simply to carry out an election promise that had no substance, that sounded good, but hasn't made any real difference at all, Mr. Speaker. Mr. Speaker, I think there are a number of things that we want to know, and unfortunately the Minister didn't touch upon. He didn't touch upon whether this actually has been put before for clearance under the Bill of Rights. Now, the Bill of Rights is a reasonably flexible document. If there's justification for suspending a right that people would normally be entitled to, presumption of innocence, then they will say, yes, it meets the requirements. But if it's just a political thing and there is no justification, I want to know that, and I want to know why we haven't yet had any suggestion from the government benches as to whether this meets the provisions in the Bill of Rights. I want to know what empirical evidence the government had in terms of justifying this on the impact it might have, because I've got the regulatory impact statement in my hand, Mr. Speaker, and it says there's no way of predicting what the cost of this policy will be, because you can't predict how the policy change will influence the court's exercise of discretion. So we might have a lot of loud noise and fuss around this, and the judges will go on doing exactly what they've done in the past. They'll look at it objectively and say, is there a real risk of this person absconding or offending? So the regulatory impact statement itself says they don't know how much impact this is going to have. And they don't know, there's no way of predicting, it goes on to say, which defendants will offend on bail and the extent to which serious offending on bail is reduced. So here we have a regulatory impact statement, Mr. Speaker, that says they don't know what the impact of the legislation is going to be. Well, actually, I would have thought the sensible thing to do is find out what the likely impact is going to be before you bring the legislation in. If you are looking at it rationally and say we're genuinely about public safety, find out what the likely impact will be. Don't work off what the National Research Unit put together as a result of polling before an election campaign. Find out what the real impact will be. So just summing up, Mr Speaker, yes, we'll support this to the Select Committee, but we will be looking at it carefully in the Select Committee to see if it genuinely does improve public safety. And if it is just political flim-flam, we'd vote against it.
Just before I call the next member, just wish to remind members to advise them that regarding cell phones and iPhones in the chamber, this is a debating chamber. It's not a place to receive phone calls during sittings of the House. We are not a call centre. Phones should be on silent mode when brought into the chamber.